Greetings, I'm Miss Taylor and I'm here to talk to you about employment law. Today's topic is very important. As mentioned in our discussion question online, it doesn't matter what industry you're going within, you have to be familiar with employment law. Whether you are working from the administration standpoint, whether you're in the front line, whether you are in the back, however you are placed in the organization, you must be familiar with employment law. I have listed a handout online on Google Classroom where you can go and view some of the laws that we're going to talk about today. The first one we're going to talk about is Title VII. It's known as either Title VII or the Civil Rights Act of 1964. I have my notes here. These are the same notes that you have in your screen. So make sure you go ahead and look at those at this time. Title VII, and it states, it permits employers from discriminating in the hiring process based on race, color, religion, sex, or national origin. It applies to only employers with 15 or more employees. So, it basically says that an employer cannot discriminate against an employee or someone who is applying for a job, a candidate, or an applicant based on their race, color, religion, sex, or national origin. So if you're black, white, yellow, a woman or female, if you're a male, if you're a transgender, any of those things, they cannot discriminate against you based on that. They have to only go based on whether or not you're qualified to do the job. Okay? Now, there are two different forms of treatment underneath that, and it's going to be disparate impact and disparate treatment. Disparate treatment is the first one we're going to read. Disparate treatment is a claim of intentional employment discrimination based upon an individual's membership in a protected class. Unlike disparate treatment, a disparate impact is a claim of discrimination that is not interested in discriminatory intent. It only looks as that in the outcome. So let me break that down for you. Disparate treatment and disparate impact. There are two different ones, and they fall under the Title VII Act or the Civil Rights Act of 1964. Basically, what that says is disparate treatment is when an employer intentionally discriminates against an employee for those different protected classes. So when an employer intentionally discriminates against an employee or an applicant for those areas, like I said, those protective classes, race, sex, national origin, religion, things of that nature. So those things are intentional, those are considered disparate treatment. And then you have disparate impact. Disparate impact is when it happens, it's discrimination that takes place against a protective class that's not intentional. Let's say, for instance, you're trying to apply, you're a female, let's just use that example. You're a female, you're trying to apply for a firefighter job, and they might have a physical requirement, or they might have a physical lifting test that you have to take. If females are usually not as strong as males, therefore, we will be discriminated against with that test because we aren't going to be able to lift as much, or we're not going to be able to pass that test even though we may make good firefighters. So women may always fail that area. So we have to make sure we are aware of those two different forms of disparate treatment and disparate impact. American with Disability Act, known as the ADA. It reads, the ADA provides that if an individual with a disability can provide essential functions with or without reasonable accommodations, that person cannot be discriminated against on the basis of their disability. Okay? Meaning, if you have a disability, an employer cannot discriminate against you based on those things if you can perform the duties with or without reasonable accommodations. If your accommodations will provide or create a hardship on the employer, then it is okay in that case not to hire you because it's just too much of a hardship on the company. But they can provide you with reasonable accommodations Now, you have to be sure that you are aware of these laws, because a lot of times employers, they're not supposed to, but a lot of times they will ask certain questions in interviews surrounding these questions, or surrounding these laws rather. And that can be a way of them determining whether or not you will be a good fit for their position or for their organization, based on these laws. So if they see you fidgeting, they might say, okay, something's not right. She might have a disability, and they might ask you these type of questions. However, that's against the law, and you need to be familiar with those laws so you can know what they are and should not ask you in the interview. Then you have age discrimination. Age discrimination is known as ADEA, and it prevents employers from giving treatment, or preferable treatment to younger workers so say for instance, let's just break it down this way. So it normally applies to adults that's 40 years and older. So it basically says that an employer cannot discriminate against an employee or someone who is qualified that is 40 years above. A lot of times people don't want to hire, or they're slower to hire people that's 40 and above due to benefits, higher benefits, packages, and things of that nature. They feel like, oh, they may call out. It's too much risk associated with hiring this person. But if that person is qualified and they happen to be over the age of 40, then you cannot discriminate against those people. So that's what the ADEA talks about. You have Fair Labor Standard Act. They're concerned mostly with your money. So they kind of talks about the overtime requirements, the salary requirements, and we're going to talk about something that's considered an exempt and a non-exempt employee. There are two different types of employees. Exempt employee is someone who is salary, meaning they are not paid by the hour. They are paid a fixed rate. Okay? And then you have a non-exempt employee who is paid per the hour, and they are able to receive overtime pay, meaning whatever their pay rate is will be multiplied by 1.5 to equals overtime pay. And overtime is normally considered anything over 40 hours, 40 hours in a week. Okay? Awesome. So we're going to make sure we know the difference. Exempt employee and non-exempt employee. I have a few cards here, you guys, and I want to share them with you. This is very, very, very crucial here. Employment at law. This is very, very tricky. I'll tell you what it says. The practice that allows employers to hire whomever they want for as long as they want, either party may terminate the employment relationship at any time. What that means and what that says is an employer or an employee can terminate their employment at any time without a reason. Okay? But you have to make sure your state and where you live, they actually go by the at-will law or the at-will doctrine. So those words are used interchangeably. But make sure that applies to your state where you'll be working. That means that you or the employer can terminate your employment for any reason. Okay? So sometimes, a lot of times when people say, oh, you got fired. What they fire you for? I don't know. What they tell me. They don't have to tell you because of this right here. So make sure when you are applying for jobs and you accept these contracts that you look and you make sure you read the fine lines and see if they are employment at will. Nothing is wrong with working for these type of companies, but you want to make sure you know, okay? Implied contract. An implied contract is an oral or written promise by an employer to consider or to continue the employment relationship either indefinitely or for a designated time. So if somebody says to you, "Oh, girl, you keep working like that. If you keep working like that, we're going to keep you around here for a long time." That's an implied contract. Be careful. Employers, be careful by giving the compliment too loosely. Whistleblower. This is very crucial, you guys. Whistleblower. It says an individual who observes an illegal or immoral action and makes the information public. An employer cannot discriminate against you for saying something. So if you see a gas leak, or if you are working somewhere where it's an unsafe work environment, you call OSHA. Your employer cannot discriminate against you. They cannot shorten how many hours you work that week. They cannot move you to another department with lesser pay. They cannot retaliate against you. It is called the Whistleblower Act, and that is your protection. EEOC. The EEOC, the Equal Employment Opportunity Commission, is a government agency created by the 1964 Civil Rights Act. It enforces the Title VII of the Civil Rights Act, the Age Discrimination in Employment Act of 1967, the Equal Pay Act of 1963, Section 501 of the Rehabilitation Act of 1973, and the ADA of 1991. That means you have to treat us the same, regardless of our protected classes. These people care about that. Make sure you look into the EEOC. Remember we talked about age discrimination? What is that? ADEA. Demeaning comments and actions directed towards older employees, such as an age-related joke, sarcasm, and labels. Remember we talked about disparate impact and disparate treatment. Okay? Let's talk about treatment first. A legal foundation for charges of illegal discrimination that is available when employment actions are improperly based on disability, age, race, religion, sex, or national origin. Disparate impact. To have the effect of discriminating, a recruitment or selection procedure is said to have a disparate impact if the activity tends to specifically reduce the number of minorities of females who are accepted for employment. It is a legal base for pressing charges of discrimination. Remember we talked about the fires? If they have a physical test that you have to take that normally hurts women in the process, this is what that's considered, okay? Workers' compensation. If you get hurt on a job, this is what workers' compensation is for. And it provides income continuation and reimbursement of accident expenses for employees, who are injured on the job, regardless of who will be responsible for the accident. Now, I want you guys to know something very, very important. If you are injured on the job, if you get hurt while you are at work, they will do a drug test first. So if you so happen to have something in your system while you are injured on the job, a lot of times that can be a determining factor on whether or not you'll get workers' compensation or not. So you want to be very, very careful. There are a lot of different laws that you guys need to be familiar with, even as some of the minors who are enrolled in Job Corps. For instance, the child labor law. Child labor law is under the Fair Labor Standards Act, and they are concerned with the conditions that you're working with, or how old you are. So if you're under the age of 18, a lot of times you won't be able to work as much as a working adult that is over 18. And they have a lot of restrictions on the hours you can work, the conditions that you can work in. Sometimes if you are over a certain age, the employer has to get parental consent, saying that it is okay for you to work over a certain time. And usually that time is 10 o'clock, but it varies per state. So that's very important for you guys to know as you're trying to work while you're at Job Corps. Also, unemployment. This is going to be the last one, but I want to make sure you guys know this. Unemployment insurance. Unemployment insurance is generally established by a state-specific law. Generally, unemployment law provides wage replacement payments to an employee who has lost their job due to no fault of their own. Employees who are Charged, fired, terminated. Discharged means the same thing. Okay? Employees who are discharged for cause are not typically entitled to unemployment benefits. Employees must fill out proper paperwork with the relevant state agency for payment to start. Employers are required to make payments to the state unemployment insurance funds based on the manner prescribed by law. So, let me explain what that means. So, depending on what it was you were terminated for, will determine whether or not you'll be eligible for unemployment insurance or unemployment pay. If you fought someone, if you were hostile, if you stole from the company, if you committed fraud, embezzlement, anything of that nature, no, you can count it out. However, if you lost your job to a layoff, to an elimination of a job just altogether, maybe a department was eliminated from the company, then that may be different. That's totally different. But you want to make sure you remember that. And that's the sentence. Let me read that again for you. Employees who are discharged for cause are not typically entitled to unemployment benefits. Now, so sometimes that situation may vary. And employees who have lost their job to no fault of their own, they typically get it. But sometimes it is a case-by-case basis. Okay? So we have so many more laws to go over, but I want to make sure that you guys got the synopsis of some of these laws that are already listed on Google Classroom. And like I said, if you can, go ahead and look at this video and look at the workouts and the handouts that's already listed. If you have any questions, go ahead and give me a call, 901-569-2098, during the office hours of 8 and between 3:50. Thank you. Bye.